Hello and welcome guys, my name is KP Singh and I welcome one and all to the 38th episode of Fortnightly Law Scoop. For those of you who are attending this session for the first time, this is what we do here. We will be discussing important news item from the legal world from last couple of weeks. So I request all of you to be ready with your notepad and pen, take down notes, pause the video wherever you feel like. If you want me to cover any particular issue, you can always leave a comment once this live stream ends. And don't forget to tell us whether you're liking these sessions or not and would you like us to add something new to it. So चलिए शुरू करते हैं. If you guys are looking for the best quality, click on the settings tab and pick the best option available on your system. If you haven't started preparing for CLAT, I would suggest you guys to check out the zero fee program available at imsindia.com. Or you can also get in touch with your nearest IMS center for one-to-one counseling. Welcome Harshit, welcome Vanavi, hello Vishwajit, welcome guys. चलिए शुरू करते हैं. The first news item is a good news for all of us. Another achievement by an Indian origin guy. Indian American attorney Arun Subramaniam will be heading the Southern District of New York as the district judge. US President Joe Biden has nominated Indian American attorney Arun Subramaniam to be the US district judge for the Southern District of New York. Subramaniam will be the first South Asian judge to serve on the United States District Court for the Southern District of New York. Currently, this guy is partner at Sushman Godfrey LLP in New York, where he has worked since 2007. Mr. Subramaniam completed his JD from Columbia Law School in 2004 and he completed BA from Case Western Reserve University back in 2001. He has also served as a law clerk for Justice Ruth Bader Ginsburg. Ruth Bader Ginsburg was the first female Jew Supreme Court judge of the US and also the second female judge of the Supreme Court. And Mr. Subramaniam also worked with Justice Gerald Lynch on the District Court of Southern District of New York. He has also worked with Justice Dennis Jacobs for the Court of Appeals. So guys, well, this photo is not appropriate. This is the guy. So kudos to Arun Subramaniam for adding a feather to his cap. Welcome Vandana, welcome Vedavit. Chaliye, another news item which concerns to all of us is the status of stray dogs on our streets. How many of you are dog persons? आप में से कितने लोगों को dogs पसंद हैं? Do you know what do the municipal corporations do with excess stray dogs? Or if some dog is suffering from rabies, a rabid dog will be put to rest. So recently in Kerala, a minor girl was bitten by a rabid dog and she died. This led to a bunch of petitions being filed at different forums. One such petition was filed at the Supreme Court. So the batch case was listed recently following an urgent mentioning by Advocate V.K. Biju. Supreme Court bench comprising of Justice Sanjeev Khanna and Justice J.K. Maheshwari was hearing this bunch of cases filed by Animal Welfare Board of India and other parties against a 2015 judgment of the Kerala High Court which permitted capturing and destruction of stray dogs. So title of the case is Animal Welfare Board of India versus People for Elimination of Stray Troubles and Others. So People for Elimination of Stray Troubles and Others. A very strange name for NGO, isn't it? So Animal Welfare Board of India decided to challenge that Kerala High Court verdict and hence this case. Senior Advocate V. Giri, appearing for the state, submitted that the situation was very grave and requested for allowing the destruction of dangerous dogs as per the municipal and panchayat laws. If you are fond of social media reels and viral videos, you would remember or might be vaguely remember a video went viral when two guys were brutally thrashing a stray dog, and there was another video in which one guy threw a puppy from third floor. So ऐसी हरकतें होती रहती हैं. Municipal corporation के पास powers हैं, panchayats have these powers. If they want, they can eliminate excess animals. So what was held in this case? Thankfully, the bench said that the procedure under the central rules will have to be followed. That means no, you cannot go with your municipal and panchayat laws, which were enacted locally by the panchayats. So Justice Khanna also stated that we have to accept that there is a problem. Dogs can become ferocious sometimes due to lack of food, sometimes they get infectious. And court is not asking that they should not be put to sleep in case of rabies infected dogs. That can be done, and even for that permission has to be taken. So even if you want to kill a rabies dog, infected dog, you still require permission and you still have to follow rules and regulations enacted by the central government. Justice Khanna is a very well-known dog lover. So if you look at what he was saying orally in the court, that will open up your eyes towards his bias. He said that a solution has to be found, and I am also a dog lover and there are many other dog lovers here. What I had thought was that people who feed dogs should be allowed to do so. They can keep a number or marking on the dog and they will be responsible for vaccinating them and bearing the cost if a person is attacked. तो आप में से जितने लोग रात को सड़क पे कुत्तों को पार्ले जी खिलाने जाते हैं, beware. If you go by Justice Khanna's opinion, then if you are feeding stray dogs, then you will be held responsible for their behavior. If they bite someone, you will have to bear the consequences, you will have to bear the expenses. And you will also have to bear expenses for vaccinating these dogs. Chaliye, so guys, don't worry, this is just an obiter dicta. So it is not the ratio of this case. What is obiter dicta? So first question for the audience. We have already discussed about ratio and obiter dictum in previous sessions. So let's see who knows the answer. Obiter dicta or obiter dictum, what does it imply? Let's see what people have to say in the comment section. Vedvat says that I have a dog. Chale, great, good for you. I hope you're getting it vaccinated, Vedvat. Harshit is also a dog lover, but Harshit is not sure what to do about it. Well guys, obiter means, obiter dicta means a thing said otherwise. In a judgment, many times judges pass comments while they are hearing the arguments. So these observations are not finding places in the judgment. That means these observations are not binding part of a judgment. These are just things a judge said in a passing by manner. When we were discussing Nupur Sharma hate speech case, we discussed about obiter dictum. When Justice Pardiwala had commented during a hearing that she is single-handedly responsible for all that was going wrong in our country, including beheading of Kishan Lal from Udaipur. So that wasn't part of a verdict. So अगर आप लोग मसाला newspapers पढ़ते हैं, so this statement of Justice Khanna was quoted out of the box, out of context. You might have read this headline that people who feed stray dogs will be responsible for bearing cost when someone is attacked or bitten by them. चलिए आगे चलते हैं. Let's move on. The next issue is a very rhetorical as well as emotional question. Do you think minors shall be allowed to donate organs in our country? Organ donation is a noble thing, but in our country, age of consent is 18. So unless you turn 18, you are not considered mature enough to give consent. Then can we allow a minor to donate his organs, his or her organs? So this issue was recently brought before the apex court of a country and a bench led by Chief Justice of India, U. Lalit. Justice Ravindra Bhatt and Justice Pamidigatam Sri Nasimha were also part of it. They issued notice on this writ petition filed by a minor boy seeking permission to donate liver to his critically ill father. Now, considering the urgency of this matter, the bench issued notice to the state of Uttar Pradesh, even though petition was yet to be formally numbered and listed. So even before the petition got listed, court bench decided to issue notice to the state of UP because there is a sense of urgency here. Parth Sarthi Bajaj through his mother versus health secretary and others. अच्छा ये बताइए guys, through mother क्यों लिखा हुआ है केस के टाइटल में? Parth Sarthi Bajaj through mother versus health secretary and others. So Khushi has a question, can minors file a writ petition? Well, Khushi, yes, they can. But generally they will do it through someone else. So therefore, in this title you will see Parth Sarthi Brajaj through mother लिखा है. चलिए आगे चलते हैं. So can minors donate organ in India? What do you think should be the judgment in this case? This case hasn't been decided as of now. अभी इसका decision आना बाकी है. Next hearing इसका 12th September को listed. So according to the Transplantation of Human Organs and Tissues Act of 1994, an organ donor has to be a major. So Chief Justice U. Lalit also noted in his order that the petitioner's son is willing to donate his liver to his critically ill father. However, in terms of the statute governing the issue, the donor has to be a major. Yes, Vishwajit, as mother is legal guardian, she is approaching court, or you can say the minor is approaching court with the help of her mother, his mother. Okay. चलिए, तो Supreme Court bench has directed responsible officer of the health department of UP should be present on next Monday, 12th September, when this matter is listed for hearing. In the meantime, court has allowed the minor to present himself before the hospital where they want to get liver transplanted. Meanwhile, hospital has been directed to conduct all the preliminary tests and to find out whether that liver is compatible or not, or even they have to determine whether he is in a fit state to donate liver or not. Right? तो feasibility check करने का permission अभी से मिल गया है. Permission to transplant yet to be decided. So what is your take, guys? क्या होना चाहिए इस situation में? पापा की जिंदगी versus बच्चे के liver का टुकड़ा. What is more important? Larger question. If this kid is a minor, then is he giving his consent willingly or is he being forced to do it? That means कि minor की consent minor रखती है. Okay, चलिए. So the question थोड़ा सा emotional है. So many of you might be inclined to say yes, and some of you will be going strictly by law and say no. Answer थोड़ा सा different है, तो हम पहले दुनिया का चक्कर लगा के वापस आते हैं. Let's look at legal position globally. So because there is always acute shortage of organs in this world, there is always this temptation to dip into the vast resource of minors. छोटे बच्चों के organs relatively better होते हैं ना, healthy भी है, vices भी नहीं होंगे, no alcohol consumption. Minors are usually not alcoholics or drug addicts. I am not too sure about your colleges, but this is the trend in most of the colleges in our country. So, if you look at the Western world, in USA, the age of consent to give organ donation is 18 years in most of the states. Exception है, in California, donors as young as 15 years may donate, but only with the consent of a parent or guardian. So, if the parent is allowing it, then even a 15-year-old minor can donate his or her organ. The youngest donation or organ donor in the American history was a 10-year-old girl who donated kidney to her twin sister. In England, Wales and Northern Ireland, there is no minimum age limit for living donors. In Scotland, however, a person needs to be 16 years old at least in order to give consent for becoming living organ donor. Whereas in France and Germany, no cases of living donations from minor have been reported. So, I told you about the European and American laws. Now let's talk about India. आपको क्या लगता है हमारे देश में क्या होगा? Pooja has a question. What is the age of that boy? Under 18. Even if that guy is 17 or 16, I don't think it should matter much. Minor is a minor. 5 साल का बच्चा तो नहीं होगा obviously. चलिए, so American history में youngest organ donor was 10-year-old. In England there is no minimum age. In France they don't allow it. So in India, as we were discussing on the previous slide, Transplantation of Human Organs and Tissues Act of 1994 prescribes a limit. It says organ donor has to be a major. So इस case में relief मिलेगा या नहीं, yet to be seen. But my prediction is yes, they will allow an exception here. Why? Because this has already happened in the past. Delhi High Court couple of years back had to decide on a similar issue. So in India, while the Transplantation of Human Organs Act of 1994 states that a donor means any person not less than 18 years of age, there was another act passed in 2011 called Transplantation of Human Organs and Tissues Act 2011. So this new act diluted the clause. Now it says no human organs or tissues shall be removed from the body of a minor before his death for the purpose of transplantation except in the manner as may be prescribed. So अब यहाँ पे exception दे दिया गया है that there can be an exception to the rule but a manner has to be prescribed. This was further clarified in the year 2014 with passing of Transplantation of Human Organs and Tissues Rules 2014. Transplantation of Human Organs and Tissue Rules 2014 mentions that living organ or tissue donation by minors shall not be permitted except on exceptional grounds to be recorded in detail with justifications. So only on exceptional grounds you have to record the details and you need to provide justification. And on top of that, you will also need prior approval from the appropriate authority and the state government concerned. तो इसीलिए इस बार सुप्रीम कोर्ट ने यूपी उत्तर प्रदेश के हेल्थ डिपार्टमेंट के रेस्पॉन्सिबल पर्सन को भी बुलाया है, यूपी गवर्नमेंट को भी नोटिस गया है, सो दैट if they want to decide in the favor of minor, immediate action can be taken. Delhi High Court Justice Sanjeev Sachdeva in 2020 had declared that there is no complete prohibition on a minor donating an organ or tissue prior to attaining majority. Even in that case, there was a girl who wanted to donate part of her liver to her father. So cases are similar. We have doctrine of precedent in our country. That means previously decided cases are binding on all future similar cases. But will a Delhi High Court judgment bind Supreme Court of India? So Riddhi Joshi says he might get the permission. Okay. Pooja says yes, he will get the permission. क्योंकि बाकी कंट्रीज अलाउ करते हैं. तो चलिए आई विल एक्सटेंड माय क्वेश्चन पूजा. क्या बाकी कंट्रीज के लॉ इंडिया पे अप्लाई होते हैं? Even if there is a law allowing a minor to donate organ in Pakistan or Switzerland or Singapore, any other country, are we bound to follow that law? No, not at all. So is Supreme Court bound to follow judgment delivered by High Court? Again, answer is no, not at all. But these foreign laws and judgments of lower courts many times will work as convincing arguments, or you can say that these will have persuasive value. So Delhi High Court judgment can be cited at the Supreme Court. It might have some persuasive value, but it is not binding at all. I hope that clarifies. Chaliye, let's move on to the next news item. Okay, so there are a couple of other news which I want you people to go through. Ashwini Kumar Upadhyay versus Union of India. Ashwini Kumar Upadhyay versus Union of India. Now this is an age-old problem that we are facing in our country. This piece of legislation has been a bone of contention between different religious groups. The statute that I am talking about is called Places of Worship Act, Special Provisions Act of 1991. So Places of Worship Act 1991 declares, well, this law was passed after the Babri controversy came to fore. So as per this law, any religious structure in our country that was erected before 1947, character of that place of worship cannot be altered. So if a place of worship was a mosque in 1947, 15th August 1947, then it shall remain a mosque. If it was a temple, then it shall remain a temple. So you cannot alter the character of a place of worship. Exception was given to Ram Janmabhoomi, Ayodhya, because there was a pending litigation regarding that place of worship which was going on for a very long time. So this act was passed to make sure that Ayodhya-like controversies are not repeated in our country. But after the Ayodhya verdict came out, even though the judges mentioned specifically in the Ayodhya verdict that this statute plays a very crucial and important role in preserving secular fabric of our country, despite of that, many other religious places got into controversies. If you remember correctly, Kashi Vishwanath से related भी controversy आया है recently, right? So मां श्रृंगार देवी temple and the adjacent mosque न्यूज में थे, हमने प्रीवियस एपिसोड में कवर भी किया है. इसी से मिलता जुलता केस कृष्ण जन्मभूमि को लेकर भी कोर्ट में डाला गया. दैट इज ऑल्सो पेंडिंग बिफोर द कोर्ट राइट नाउ. देयर आर वेरियस अदर प्लेसेस ऑफ वर्शिप जिनको लेकर कंट्रोवर्सीज चल रही हैं. वी ऑल्सो डिस्कस अबाउट अ जैन टेम्पल वेयर कैरेक्टर वाज बीइंग चेंज्ड फ्रॉम वन सेक्ट ऑफ जैनिज्म टू अनदर सेक्ट ऑफ जैनिज्म. And court declared that no, places of worship is only applicable when a place of worship of a particular religion is being transformed into place of worship of some other faith. It will not apply on intra-sect disputes. So Ashwini Kumar Upadhyay is a senior BJP leader and also a very well-known advocate. He has filed this case initially, and now Kashi royal family की princess जो हैं, daughter of Kashi royal family, Maharaja Kumari Krishna Priya, has become party to it. Another petition on similar lines was filed by Jamiyat Ulema-e-Hind. They have also moved Supreme Court to make sure that this statute is not removed. Rather, they are seeking proper enforcement of Places of Worship Act. I want you people to also go through Janhit Abhiyan versus Union of India with 32 connected matters. Janhit Abhiyan versus Union of India. This case relates to the economic weaker section reservation being provided in our country. So a 5-judge bench has been constituted. Chief Justice of India U.U. Lalit, Justice Dinesh Maheshwari, Justice Ravindra Bhatt, Justice Bela M. Trivedi and Justice Pardiwala. So ये 5 judges हैं, constitutional bench है. Constitutional bench means 5 or more judges in odd numbers, and in every constitutional bench, Chief Justice of India is also a member. Constitutional benches are constituted or created in order to decide upon the substantial questions of laws relating to interpretation of constitutional provisions. तो संविधान के किसी प्रावधान के इंटरप्रिटेशन के लेकर अगर सवाल उठता है, तब कॉन्स्टिट्यूशनल बेंच बनाई जाती है, संवैधानिक पीठ. So they took up the cases challenging constitutional validity of the reservation for economically weaker section. The bench decided that it will be proceeding proposed the 3 issues suggested by the Attorney General of India. चलिए, तो 2 सवाल है आपके लिए. ये बताइए, EWS रिजर्वेशन दैट मींस इकोनॉमिकली वीकर सेक्शन के लिए कोटास किस अमेंडमेंट एक्ट से ऐड किए गए हैं? बाय विच अमेंडमेंट एक्ट इकोनॉमिकली वीकर सेक्शन कैटेगरी वाज क्रिएटेड and government was empowered to make special provisions for the upliftment of economically weaker section. Vishwajit says 131st. That's incorrect, buddy. 131st is incorrect. What about others? Okay, and another question would be, who is the current Attorney General of our country? Attorney General is the chief law officer or the first law officer of the nation. He is the main representative of the union government at the apex court. So central government के वकील जो उनको सभी केसेस में बचाते हैं, वो अटॉर्नी जनरल कहलाते हैं. So K.K. Venugopal is correct answer, and the correct answer for the previous question, that means the Amendment Act which added EWS category, is 103rd, as you can see on your screen. So these are the 3 issues that will be decided by this constitutional bench in the upcoming weeks. The questions are whether 103rd constitutional amendment can be said to be breach of basic structure because it is permitting the state to make special provisions including reservation based on economic criteria. Earlier, constitution provided for affirmative action in favor of backward groups based on 3 parameters: social backwardness, educational backwardness and economic backwardness. So if you have triple layer backwardness, that is economic, educational and social, then you will fall under scheduled caste and scheduled tribe category. If you have double layer backwardness, that means if you are educationally and economically backward, then you will fall under other backward classes or OBC category. After the passing of 103rd Amendment, government created a special category with only single layer of backwardness, and that is economic backwardness. So all those people who were not considered or who were not falling under any reserved category earlier, the so-called general category people, if they fall under economic weaker section, then they will be allowed to claim reservation. So EWS category. So first question is, क्या ये 103rd Amendment Constitution के basic structure को violate करता है, because it is permitting state to make special provisions including reservation based on economic criteria. Second question again, is the 103rd Amendment violative of basic structure because it is permitting state to make special provisions in relation to admission to private unaided institutions, so private colleges maybe. And third, is it violating basic structure because it is excluding SCBCs, OBCs, SCs, STs from the scope of EWS reservation. So EWS reservation में बाकी categories को नहीं include किया जा रहा है. So let's say if I say that someone is economically weaker, यानी अगर आप आर्थिक रूप से पिछड़े हैं, तो अगर आप आर्थिक रूप से पिछड़े हैं और साथ साथ में आप एजुकेशनली भी बैकवर्ड हैं, सो ओबीसी और ईडब्ल्यूएस में सिर्फ इतना फर्क है कि ईडब्ल्यूएस कैटेगरी में एजुकेशनल बैकवर्डनेस नहीं जोड़ा गया है. सो I can say that people falling in general category will not qualify for OBC criteria क्योंकि डबल लेयर बैकवर्डनेस नहीं है. लेकिन क्या EWS में OBC कैटेगरी के बच्चे अप्लाई कर पाएंगे? बिकॉज इकोनॉमिकली वीकर सेक्शन तो वो भी है. Vedamit, answer for the question was 103rd Constitutional Amendment. 103rd Constitutional Amendment से इंडिया में इकोनॉमिक वीकर सेक्शन का क्राइटेरिया जोड़ा गया. अच्छा, this amendment also amended two important provisions from Part 3 of Indian Constitution. So कौन से दो आर्टिकल्स को ऑल्टर किया गया था 103rd Amendment से? That could be additional information. So which article of Indian Constitution talks about equality in matters of public employment? तो सरकारी सेवाओं में सबको बराबर मौका मिलेगा. ये कौन सा आर्टिकल है कॉन्स्टिट्यूशन का जो बताता है? And no discrimination on the basis of race, color, caste, creed, gender, place of birth. ये किस आर्टिकल में लिखा है? Yes guys, so equality in matters of public employment article 16 है, and no discrimination on the basis of certain grounds like race, color, caste, creed is article 15. So जब रिजर्वेशन की प्रोविजन बनाए जाते हैं तो आर्टिकल 15 और 16 में भी चेंजेस किए जाते हैं. फॉर एग्जाम्पल आर्टिकल 16 Clause 4 says that government can reserve seats for backward segment of society if they are not adequately represented in government services. Article 16(4)(a) says that this reservation can also be extended to people belonging to scheduled caste and scheduled tribe categories. चलिए, तो सवाल ये है कि क्या EWS के लिए बाकी सब भी क्वालिफाई करते हैं? आंसर यस भी हो सकता है, नो भी. तो अगर आपका आंसर हाँ है कि हाँ, सभी इकोनॉमिक वीकर सेक्शन के बच्चों को, चाहे वो ट्राइबल हैं, चाहे वो एससी हैं, चाहे ओबीसी हैं, उनको ईडब्ल्यूएस में गिनना चाहिए. देन बाय दैट सेम लॉजिक all people belonging to SC and ST will also claim reservation in OBC category because OBC के लिए डबल लेयर बैकवर्डनेस चाहिए और ट्राइबल या SC के लिए ट्रिपल लेयर बैकवर्डनेस है. So if you have triple layer backwardness, you will also qualify for double layer backwardness. So these are the questions that I don't have to decide. Thankfully, Supreme Court of India Constitutional Bench will have to take a call, and till then we will wait and watch and we'll debate and discuss. So chaliye guys, so I covered all the major news items from last 1 week. So this is all from my end. Thank you so much for attending. Don't forget to like, share and subscribe. If you like our content, if you want me to cover any particular topic, any news item, you can leave a comment once this live stream ends. Thank you so much for watching. Keep sharing. याद रखिए, बांटने से ज्ञान बढ़ता है और साथ में सब्सक्राइबर्स भी. Bye.